A tragic death shocked the community in Galveston, Texas. A 17-month-old girl was found dead after falling from a third-floor balcony, and authorities say her own mother may have caused this fall. But now, prosecutors have made a pivotal decision that changes the stakes for this upcoming trial. We're going to break it down with a Texas-based trial attorney and get her insights into this case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Just a heartbreaking story out of Galveston, Texas we want to talk about. This Houston woman is facing serious charges after her 17-month-old daughter died in what authorities are describing as a shocking and deliberate act. That's the key. And now, prosecutors have made a major decision that changes everything. It changes the whole stakes for this upcoming trial. In October of 2024, emergency responders were called to an area near 59th Street and Seawall Boulevard after reports of a child that was injured on the street. According to a probable cause affidavit by Detective Matthew Larson, officers arrive and they find this small pool of blood on the street and a white blanket partially on the sidewalk. Hannah Yonko, just about a year and a half old, was already in an ambulance and rushed to the hospital. Now, tragically, she did not survive. Hospital personnel pronounced her death at 10:34 a.m., and investigators noted that she had 3 puncture wounds on her back. So that could suggest that those injuries may have occurred prior to her fall. And that is when investigators quickly uncovered shocking details. Surveillance footage from the Beachfront Palms Hotel allegedly captured the moment that Hannah fell from a third-floor balcony. And authorities believe that her mother, 30-year-old Hannah Yonko, intentionally caused this fall. A trash bag recovered from the hotel's parking garage contained a knife, a hotel room key, plastic sand toys, unopened diapers, and snacks. Witness accounts, including statements from Yonko's sister, added even more context. The sisters had been sharing a hotel room with Hannah, and on the morning of the incident, the sister left to meet her fiancé at another hotel. Now, Hannah Yonko apparently later appeared at the Victorian Hotel pushing a stroller, but her sister didn't see Hannah in the stroller, had no reason to believe that the child wasn't there. And when her sister suggested returning to the hotel to get their luggage, Yonko reportedly insisted they shouldn't go back. So police, they acted quickly after reviewing witness statements and the surveillance footage, and they identified Yonko as the suspect. She was arrested at a nearby restaurant. She was charged with capital murder. Pre-trial hearings revealed that she would be represented by counsel, had requested to speak with a lawyer rather than providing statements to police at the time of her arrest. According to Houston Public Media, Yonko even underwent a psychiatric evaluation following her indictment. Psychiatrist Edward Grippin concluded that she was competent to stand trial, meaning she understood the legal process, could participate in her defense, and Yonko reportedly denied using drugs or alcohol, but did disclose that she had sustained past head trauma and occasional forgetfulness. Forensic psychologist Dr. April Alexander has been asked to provide insight into how such evaluations work and how mental health factors might be considered in death penalty cases. And when we talk about Miss Yonko, so ABC 13 dug into her past, and they viewed a marriage certificate for her and an 80-year-old man from 2017. 2 years after the marriage, the man filed to have it annulled, saying he was tricked into marrying her and that the marriage was never consummated. This again, according to ABC 13's reporting. And to make matters even worse, Yonko reportedly has a documented history with the Texas Department of Family and Protective Services, which investigates child abuse and neglect. That's according to what a spokesperson for the department told Houston Public Media. And Houston Public Media reports that one of her other children required medical attention in 2019 after being found with, quote, blue lips and a red body in her crib. That incident involved intervention by Child Protective Services, although, to be clear, no neglect charges appear to have been pursued. But that is interesting and that is significant. And by the way, talking significant, there's another significant update that we want to talk about. The Galveston County District Attorney's Office has announced that it will not seek the death penalty at this time. Now, you may think by watching Sidebar you've seen it all. Let me tell you, think again. 50 Ways to Catch a Killer. Okay, this brings you real cases where detectives had to flip the script to take down cold-blooded killers. Hosted by 50 Cent, this isn't your typical crime show, okay? It is a high-stakes, twist-filled ride into the minds of investigators who think outside the badge to break the case. From unforgettable setups to shocking reveals, every episode proves when killers think they got away with murder, think again. Watch 50 Ways to Catch a Killer with 50 Cent exclusively on Fox Nation. KHOU 11 reports that during a pretrial hearing on September 17th, Assistant District Attorney Casey Kirst informed Judge Patricia Grady that the office would not pursue capital punishment, and now the question would be why. So to help me break down this development and more, I want to bring on trial attorney and former prosecutor Bridgette Williams. Thank you so much for taking the time. I want to start right there. From a legal standpoint, what does it mean for the DA to decide not to seek the death penalty in a case like this? Because you're talking about the death of a child. I imagine there are probably aggravating factors that would permit the death penalty to be pursued. What does it mean? Why do you think it's not being pursued?
So the death penalty in the state of Texas can come into play for multiple reasons. The death of a child is one of those. A person can be charged with capital murder if they are being accused of killing a child, right? So that is one of the ways that a person can be charged with capital murder and also have the death penalty against them. Now, it is up to the district attorney's office to make the decision on if they want to pursue it or not. The district attorneys have a range of punishment where the death penalty is the highest when they're being charged with capital murder, right? So they can choose if they want to move forward with that based off of the evidence that is presented to them. It's like you just stated, there could be extenuating circumstances, that could be mental health issues, that could be other factors that defense counsel has presented to the DA's office to help them to come to that conclusion. Now, that is this district attorney's decision. If another district attorney comes along prior to them making this agreement final, before she actually agrees to a plea, a different district attorney can make another decision, right? So it's the range of punishment that they can move forward with, and they can choose not to move forward with if they want to or not.
Do you think that some of the factors are, if we make this a death penalty case, it's going to extend the whole process? Death penalty cases notoriously can take longer than traditional cases. And there may be a concern, given any kind of mental health considerations, it may be difficult finding a death-qualified jury. In other words, jurors who are open to imposing the death penalty if the facts and evidence lead them there.
That's a great point, JC. I think that, one, death penalty cases do take a lot longer than a murder case. A lot of times murder trials can last, goodness, weeks. A death penalty case can last even longer than that. And when we talk about finding a jury that is open to the death penalty, especially in a county such as Galveston, it's a smaller county, and you may not have individuals who may be open and who can be completely unbiased, right? Someone who doesn't have views that are for or against the death penalty, but they can have an unbiased opinion about it. And so that is something that when we consider that, that the jury is someone that can be unbiased or not, the prosecution is going to take that into consideration 110%.
Now, here's the thing, though. If this was a death penalty case and it was an option for punishment, time and again, we have seen that that can be used as a bargaining chip. That can be used to have a defendant plead guilty where the death penalty is taken off the table to avoid a trial, particularly in a case as with this kind of difficult subject matter. I don't imagine prosecutors would want to expose a jury to all this, the photos of all this, if they don't have to. They just, now with the death penalty off the table, that is giving less incentive for Ms. Yonko to plead guilty.
Well, I think it's not just the prosecution that wanted to show that to a jury, but if I was defense counsel, I don't know how I would want to, move forward with showing the evidence of a 17-month-old to a jury either. That's not going to go over well. And so defense counsel may be talking with Ms. Yonko about how will that be seen to a jury as well if you were to move forward in a trial setting. So taking the death penalty off of the table may give her some incentive to plea to another plea offer that the state is offering to her instead of moving the case to trial.
How do you prosecute a case like this? How do you build a case like this where you're basically saying a mother brutally killed her young daughter in horrific fashion? This is not an easy case. How do prosecutors build a case like this?
It's not an easy case. It's not an easy case for anyone to really to stomach, right? Because I mean, there's so many specific details that are just so graphic with this. You have a young child who's thrown over a balcony, who has puncture wounds as well, who is, has broken bones. You have different things that are going on here. And the state has to move forward and actually showing those pictures and that information to a jury. It's going to be a very heart-touching type of trial. And the prosecution, again, and defense counsel, either one of them, I wouldn't want to move forward with a trial like that unless it was necessary if I'm defense counsel. And so just having that conversation with Ms. Yonko, if I'm defense counsel, telling her these are all the things that are going to come out in the prosecution. These are all the things that are going to come out to a jury, and they are going to have all of this information, and that could easily increase it if the state takes it off of the table of the death penalty. If you decide to go to them for punishment or anything like that, they could take it back up and to the maximum allowed for her to go to prison. So it's several different things there. If I was defense counsel, I wouldn't be asking or talking to her, encouraging her to move forward in a trial setting like this.
Surveillance footage is a potentially key piece of evidence in this case. You talked about defense counsel. How do they challenge it? How do they challenge its use? How do they challenge it? How do they challenge it being interpreted by a jury? Because isn't it pretty clear cut or no?
It can be pretty clear cut. They would have to just make sure that they know, okay, what the evidence from a video was taken from an independent source, right? Is it something that can be admitted into evidence? But most of the time, something like that is going to be able to come into evidence. A court would allow a video to come into evidence like that, and it will be up to the jury to decide on if its value is important for them to decide if it's something that they can use to determine guilt or innocence. So it's more than likely, I'm gonna say 99% of the time, it's coming into evidence.
I'll tell you what I think is pretty compelling: the puncture wounds, the trash bag with the various items. When you're talking about physical evidence like that, how do you think that's going to factor into the prosecution's case?
I think there's just so much overwhelming evidence in this particular case. Like you just stated, the puncture wounds from the child, the video, the trash bags, the room key that comes in the trash bags. I mean, there's just so much overwhelming evidence that could come into play for Ms. Yonko in this case. And so with that being said, we don't know exactly what defense counsel may be talking to the prosecution about, but I presume it's something that is imperative that allowed for them to reduce their offer from the death penalty down to just a murder case. But all of that evidence is still overwhelming, and that is evidence that wouldn't play out well for her in a trial.
Because here's the thing, even if the defense, and I don't know if they're going to do this, but even if the defense were to say, this was a complete accident, this young girl fell off the balcony, the argument would be, you have a mother who's still trying to cover it up and acts like nothing's there and doesn't want to go back to the hotel, is pushing the stroller, the child's not there. I've covered cases before where somebody will say, listen, I didn't kill this person. I panicked, I disposed of the body, I tried to cover it up, but you can't prove I murdered the person. Okay. Doesn't it feel different here? Because the immediate reaction would be, call 911. I mean, the immediate reaction, if it was a panic, again, I'm struggling. I'm struggling to find how this could make sense, because the other way of saying it is, in those other cases, is somebody panicked, they didn't want to be, they thought that they would be accused of killing that person. They didn't know what to do. They disposed of the body. But this one feels different when you're talking about a mother and a child, right?
It does. I mean, all those things that you just mentioned, but in addition to that, the puncture wounds on the child. That's a thing that I just can't necessarily get over.
They'll have their own expert. They'll have their own to say, oh, those injuries were caused maybe by the fall or something else.
Yeah, I mean, that's true. But if I'm a prosecutor, I'm going to be moving forward with, well, do these puncture wounds show or resemble something that is or could have been caused by the fall, right? And the prosecution will have their expert that says, well, no, it wasn't. That was caused by a knife or whatever it may be. And so, I mean, I think that there's just, again, so much evidence against this woman for to show that this was intentionally done. There's just so much overwhelming evidence. I don't really see anything that says that this was an accident and that she didn't mean to do this.
Talking about what comes into evidence, her reported prior involvement with CPS, those CPS reports, this prior incident with her other child, can any of that be used as evidence in this trial? Is it relevant, or is it too prejudicial and won't be allowed in?
I think it's relevant, but it's up to a judge to determine if it's going to be something that's allowed into evidence for a trial. So prior bad acts, that's going to be something where the state will more than likely raise motions to bring that into evidence, and defense counsel can and should object to allowing any type of prior bad acts to come into evidence. And then it's up to a judge to determine if it is the value of that being allowed into evidence is in fact worth it for the jury to hear. And so it depends on the judge, honestly, because a judge can say yes or no.
This is a case that also has that mental health component. They talked about that a psychiatric evaluation was conducted to determine competency. We talked before about past head trauma or memory issues. They're sort of related, sort of not related. What are you taking away from those aspects of this case and how it might factor into a trial?
When we talk about mental health, the point that the court cares about is the person competent? Are you competent enough to stand trial? And do you understand right from wrong? Do you understand, what exactly is going on here, right? Do you understand what we're doing here? And so her mental health evaluation determined that she was in fact competent. So everything else will just be what we call mitigating circumstances, mitigating factors in a discussion probably with the prosecution prior to moving forward to a trial. So if we are going back and forth with negotiations with the prosecution, then I would just bring up that information that she's had prior head trauma, she's had memory loss. And who knows, that may be evidence that the state used to reduce it from a capital murder case, right? So that may be something that they did consider. But the court itself, their job is to determine, is she competent? And she was in fact deemed to be competent.
Is it possible there's a defense due to significant head trauma, the defendant doesn't recall what happened to her daughter, has no understanding what happened to her daughter, that she acted in a way that maybe doesn't indicate guilt, but indicates a lapse with reality, a lapse with understanding what happened? It's not necessarily, I wouldn't say insanity, but something else. Have you seen anything like that?
Yeah, I don't think that rises to the level of insanity, but I
No,
get what you're
yeah.
saying there. What I would say is that um, if she has an expert witness that can testify that, well, based off of what I have evaluated with her, she often has lapse in memory. She also has lapse in judgment. She, has all of this, and she has a history and a pattern of that. Then that may be something again that the court allows into evidence. That is something that happens generally in the pre-trials where the defense counsel may ask a judge to allow that into a trial. And again, the judge is the person who makes the determining factor or makes the determining decision on if that can be allowed into evidence. And it just depends on if they say yes or no.
Now, I will say, despite the uncertainty regarding the death penalty at this point, this trial is scheduled to begin on December 1st, 2025. It's expected to last 2 weeks. When you think about this, it seems like more of an advantage for the prosecutors on jury selection, who they will want. Who does the defense want to sit on a jury like this?
Immediately, you're going to want people who do not have small children, right, or have ties to small children. If you're defense counsel on a case like this, and that's the first thing off the top. Then you want to make sure that they are individuals who are have not had any type of feelings towards the death penalty, even if that's taken off the table. I still would want anybody who has views about that on that. I would also, if I was defense counsel, I want someone who understands the gravity of mental health and how it can really impact a person on their day-to-day life. And not just understands it, but they have a view that says that this could really have happened in this case. So someone who's open-minded to that point and not biased against that to just say, well, no, that couldn't be a factor before they even start. So both sides are going to want someone who can be unbiased and that can have just a fair point to both sides. They come in, they look at the evidence that is presented from both sides, and they can make a determining decision based off of that.
It's such a horrible case. It's so sad. And we've been talking the legal points about it, but from a human point of view, it is just very hard to imagine. Bridgette Williams, thank you so much for coming on. Appreciate it.
Thank you for having me.
And that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on Instagram or X. I'm Jesse Weber. I'll see you next time.